Hey everyone, and welcome back. Today we're looking at a divorce court case featuring a woman whose behavior turns the hearing into complete chaos. It's a reminder of how quickly relationships can become messy when emotions take over. I found today's case on the channel I'll Talk with Mike. So if you enjoy this kind of courtroom content, be sure to check out his channel after this video. Now let's get into it.
Morning. How are you all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir. Get us off of your docket is what you could do.
Oh, you'll be off the court's docket one way or another. It just might not happen the way you were hoping.
Go ahead, Lacey. Start talking.
That's pretty specific. Miss Kimball?
Yes, sir. Specific.
Go ahead, Miss Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Yeah, keep disrespecting the court like that, and a civil divorce case can quickly turn into a criminal contempt issue. That's not a direction anyone wants a hearing to go.
Talking. You'll be able to respond in just a second. Miss Kimball, you can go ahead and finish, and then Miss Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
You can probably see why her previous lawyer chose to withdraw. And unlike a criminal case, the court generally isn't required to appoint an attorney for someone in a divorce proceeding.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me. Or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions. And then we ultimately never got a response, and she filed a motion for protection.
She got plenty of responses. Objection.
Hold on. There will be a time for you to raise your objections, but interrupting the court isn't helping your case. If anything, it's only making the situation worse.
How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents Cody and all fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So Ms. Kimball, why don't you just go ahead and finish telling me so you said that you're wanting a drug screen, so a drug test, and do you say psychological or psychiatric? I thought you said
psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition, and for attorney's fees for $1,500.
All right. So, Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll file for marijuana.
Did you really just admit to committing a crime in front of the judge for no reason? That's about the last thing you want to do in a courtroom.
When was the last
But
time?
I'm happy to take it
When
on
was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
I hate to break it to you, but take a look at the flag behind the judge. You're in Texas, not California. The laws are different, and what may be legal in one state isn't necessarily legal in another.
So I'm glad to take your request.
Stop.
Okay, go. It's going to be on his expense,
Stop.
but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can
Kimball.
just, if you're gonna use my last name, that's fine. Just say Judge Tenig. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenig.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no?
Actually, the court can order evaluations that are relevant to the issues in a divorce case. Based on her behavior during the hearing, it's not surprising that a psychological evaluation was brought up. When someone appears unusually erratic in court, the judge may see that as something worth examining before making further decisions.
Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your
That's
position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
Yes, you're going to have to answer the judge's question. In court, the judge controls the proceedings, and refusing to cooperate or repeatedly arguing with the court is only likely to make your situation worse.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee. Woo
Okay,
woo.
well,
Based on your behavior and the fact that you asked for a court-appointed attorney, it doesn't seem like piling up financial penalties is going to help your situation. It would probably be in your best interest to cooperate with the court before those sanctions continue to grow.
so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want that.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
what
been
date are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting, how long? That's a valid question. Is it half day, an hour, 2 hours? What do you
I
anticipate?
would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempt.
There's only one person making themselves look bad here, and it's the one who keeps turning off the camera instead of cooperating with the hearing. Every interruption only hurts her own case.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
So that question is to you. Never
I
mind.
said what
I'm
time?
not gonna let you
Time,
pick.
date, you know, these
I'm not gonna
things.
let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that.
Well, that's one way to end your own participation in a hearing. The divorce case continued for another 20 minutes without her, and missing the rest of the proceedings certainly didn't help her position. That's it for today's video. If you enjoyed it, leave a like, subscribe, and turn on notifications so you don't miss future uploads. Thanks for watching, and I'll see you in the next one.
As another violation. So in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record that she opted out after flipping the off.
That's a pretty wild misunderstanding. It almost seems like she completely misheard the judge's question, and her response only made the exchange even more confusing.